To the wafting tones of the Perry Mason theme. That's right, a long-departed television lawyer. David Whiting not available for us today, but congratulations to the Whiting family, excuse me, for what it is that, in fact, takes him away from our studio. He is moving his daughter's admission in the Supreme Court today, which is a very exciting thing. In his place, very generously, Sally Nicholes from Nicholes Family Lawyers has agreed to come in, and we can devote the entire session today to family law problems exclusively. 1300 222 774. 1300 222 774. You can adopt whatever name, whatever suburb, your best friend, someone you met at work, whatever it might be for anonymity's purposes. We're more than happy to engage in whatever level of subterfuge you need in order to get your questions answered by Sally Nicholes, who's here to take your calls. 1300 222 774. 1300 222 774. Sally, good morning to you.
Good morning.
I understand there are moves afoot to try and make things better, if not easier, for people who represent themselves in the family court. What's being proposed?
Well, what's been proposed by the government is a third tier, if you'd like, to the family court. There'll be a court specifically designed for litigants in person.
So what we have at the moment, if you've got an actual, what's called a trial, like a full-blown case, which is about 2% of cases or something that end up going to?
Exactly, a very small number actually go. But
so we have a judge for those?
Yes.
And then you've got
the family court that has 15% of cases. Mm-hmm. Then you've got the Federal Circuit Court, which has got about 75% at the moment, but there's an absolute
what sort of cases do they deal with in the Circuit Court?
In the Circuit Court, they deal with what's considered to be your less complex cases, less money, more daily house and garden type cases. But
disputes about children
and property. But there are still complexities throughout it and huge queues. One judge, a Federal Circuit Court judge, might have 30 people in the list or 30 parties in the list in one day.
For one day?
Yeah.
30 people's problems to sort out in a day.
That they can't resolve themselves,
15 before lunch in 3 hours, that's 5 an hour, that's 12 minutes each.
It's
that's
impossible.
Ridiculous.
So the solution, rather than creating more judges or creating, or going back to our old world where we had a world-renowned system in the old days when I first started, where we had multidisciplinary approaches, we had court counsellors for any kids matters to assist parties. We're now reverted to creating a third stream for litigants in person.
Now, what does a litigant in person mean?
Unrepresented by a solicitor.
You can't get legal aid and you can't afford a lawyer.
Exactly.
Now, what happens if one party's represented by a lawyer but the other party isn't?
As far as I understand, you won't have access to that third tier.
But if both parties are representing themselves...
That's right.
So it's like a small claims tribunal for family law.
In a way, but the problems are still real. They still, I think if they reach that level, need some assistance to be able to help resolve them. And it will be... concern about what happens when they appeal those decisions, because it will come back to the family court.
Except if you can't afford a lawyer for your initial hearing, you're unlikely to be able to afford a lawyer for an appeal.
That's right, but you'll be back
So
here.
in fact, what happens is you walk away feeling unhappy and angry.
That is a concern, or you appeal as a litigant in person. And constitutionally, you can't be stopped from doing that.
But whether you, in fact, can actually properly express your appeal point
exactly
is another thing. But it's a process of attrition, isn't it? Fewer and fewer people get through. We end up with a very unequal system, and we end up with something I always thought we would avoid, which is one system for people with money and another system for people who don't have money.
And very unhappy people without having that buffer of a lawyer to help diffuse situations.
You get some unhappy people with a lawyer too, though. Sorry about that, Sally, but it is true.
You do.
Okay, so that's how far down the track is that?
It was announced in the next budget, so I think there's a pilot project being put together in Parramatta, as I understand it.
And then they'll iron out the kinks and then extend it maybe nationally.
That's right.
Well, certainly worth trying, because whether not just in the family court but in all the courts, litigants in person are a bigger and bigger part of the turnover, and of course it slows everything up because they don't know how the procedures work.
It is a concern, but again, my view is that everybody should be entitled to have representation, and that's the issue that needs to be addressed.
Instead of funding a third level of court, just fund legal aid properly.
Exactly.
Yeah, well, that would solve that part of the problem, but that's, there you are, I'm howling at the moon. Other things, are there any other changes before we get to the callers? 1300 222 774, specifically family laws. So there's big changes in family violence orders. There's been an extraordinary turnaround in the last 12 months or so.
Well,
on that front.
That's right. Family violence is high on the agenda. There has been some cases, that we might have mentioned it last time, where I feel still that family violence, the avenues of dispute are being used in proceedings. We've had a few magistrate claims where I've felt it's been used unfairly in terms of children's cases to get a strategic advantage, and some of the claims have been a bit nefarious, but otherwise I think the push towards empowering family violence victims to come forward has been overall really positive.
Is technology changing family law?
It is, in terms of, for one area, stalking, for example. We're finding that the use of placing apps on phones or
to spy on your spouse.
Yeah, or your ex-spouse. And we're trying to keep up with that. There's been a few cases where it's been a bit challenging in terms of working out some of these technically proficient people have been able to actually use technology to harass and stalk an ex-spouse, which has been quite disturbing.
I kind of meant the other way around. For instance, I met a lawyer recently whose family law practice is entirely on Facebook. They don't have an office.
It's virtual.
It's all done online. They advise people. They help people with documents. They do everything from the kitchen table.
I think we will get there. We need to become paperless. That's important. But Facebook, that's a new phenomenon.
No overheads.
Sounds nice.
You can offer cheaper rates accordingly. But I'm wondering if also, the day where, if I'm just imagining, I know now there are kits where you can go and see a lawyer and the computer generates your will. So you answer a whole lot of questions about your family circumstances, the names of people, the dates of birth, what relationship you have to them, and then bang, it spits out a will.
Yeah,
you don't ever sit down opposite a lawyer. You do it all on the computer.
I think there are advances for gathering information, and that will be really important. I think with family law in particular, you do need to actually eyeball a litigant from time to time because they could be extremely distressed. We often have to actually assess risk, for example, in terms of family violence, and it's really difficult to do that on a checklist. But there will be advances that will assist people, but that human element of family law, I think, will never change.
1300 222 774. Let's get to your calls. And in Malvern, Tony's first. Hello, Tony.
Hi, guys. Thanks for taking my call. Hi, Sally. My situation is that my ex has discontinued his application in the Federal Circuit Court to see our children. There's been a restraining order for over 12 months. I'm unwell and I just wanted to know, what do I need to do to put in place to ensure my children are cared for by a nominated guardian if I was to pass away?
I'm really sorry to hear that, Tony. That's a really distressing situation, and just adds to what you're going through. Do you have, in terms of the restraining order, was that actually in terms of yourself and the children, or?
It is. It's in terms of myself and the children, and I'm going through a process to extend it until they're 18. There's been a long-running history of family violence.
Yeah, I understand. And you probably have you received advice that you may leave instructions in your will, but that doesn't necessarily bind the family court in the future? Have you been given that type of feedback?
Yeah.
So as a result, when people are in your situation, and we've been assisting clients at the Alfred through a program actually, who have your similar situations, you can actually, if there's somebody who you believe would be the appropriate parent or guardian for your children, if you were to pass away, you can actually seek an application now while you're still with us, and you can prepare the material that they actually have with you, joint parental responsibility. And I have actually
sort of as a handover period if you know you're dying.
Yes.
Yeah.
By survivorship,
right,
the children, there will be an order that person has all the obligations and the old guardianship type orders that we now call long-term parental responsibility. And I have done that successfully for a number of people where there's been a really appropriate, outstanding parent that you nominate, and that can be done in the family court. And
So you mean guardian type person to replace a parent?
yes.
So is Tony's predicament, if and Tony, I wish you all the very best, of course, and hope
Thank
that
you.
things don't turn out that badly, but is part of the thinking there, Sally, that if you can have the guardian with the unwell parent together over a period of time, then you establish a stronger case in case it's challenged by the other surviving parent.
Practically, but all parents automatically have guardianship rights when a child's born. When there's a dispute from time to time, one parent might argue that they should have sole parental responsibility, which is like saying they have sole guardianship for making long-term decisions about a child. So in the family court, if there was somebody who you believe would be appropriate, we could actually seek that you retain that guardianship right and obligation, but also we would actually seek that other person has orders now with you jointly, so that if you were to pass away, those orders would remain on foot, and that person would be effectively the guardian at law, which is far stronger than an intention in a will.
Okay.
And so if you've got that period of co-parenting, it's not the same as saying, Tony from Malvern is handing the children over to someone who's in effect walking up for a fresh start. You've got an overlap period to say
That's
to the
right.
court, this has been working. Okay. Do you get that, Tony?
I do. I've not heard that advice before. It's never been provided to me, so I'm just wondering how I go about initiating that process now.
Sure. Well, again, absolutely, if it's appropriate, you can ring my office and
Tony, are you...
I'm happy to help on a pro bono basis with that, Tony.
Well, that's
Thank
very
you.
generous,
I
Sally.
really
But
appreciate that.
Tony, are you being treated at any of our major hospitals? Because
I am.
the social workers in all the hospitals, I think, Sally, have... I mean, I'm not just thinking of you, Tony, but all the people who are listening. The social workers are the people who often have people like lawyers they can contact.
We run a program at the Alfred called Alfred Help, and Morris Blackburn are actually the main protagonists of it, but I actually do the family law work there. So I've had the unique experience of actually acting for people in your situation where the social workers will actually contact us to assist people in your situation. I'd be very happy to talk to you about it if you would like to ring the office.
Tony, I'll pop you back on hold.
Okay.
And
Thank you, Sally. Thank you.
It's a pleasure.
And we'll make sure we've got whatever necessary contacts need to. I think all the hospitals have visiting lawyer schemes, in particular for wills and estates and things these days, Sally. So, I was doing wills at St Vincent's in 1984, 5, 6 and 7. And at Fairfield Hospital when it was open back in the 1980s when I was at Fitzroy Legal
It'd be wonderful
Service.
if they did. I know at the moment that Alfred's considered quite unique. Michael Kirby established it recently.
Really?
Yes.
We were doing it in the 80s. I don't want to sound like, but we were doing it back in the day. But the social workers would ring us at the legal service and we'd rock up and do a will on the spot.
I'd be really happy if that was the case. From what I understand, the Alfred's quite unique with this program, but it would be sensational if that wasn't the case.
Tony, I've popped you back to my producers. Let's move on. In Thorpedale, Tessa, good morning. You're through to Sally.
Oh, hi. Thanks very much for taking the call. Sally, I just wanted to ask, I've got two sons, a 14 and a 16-year-old, and there's no parenting agreement in place. The boys have just basically been let to do what they wanted to do.
So they walk with their feet a little bit, we often say. They make their own decisions.
Well, they've been forced to by their father because he hasn't wanted to put a parenting plan in place because he hasn't wanted to negotiate. He wanted them full-time and I couldn't say yes to that because I had to leave due to family violence. But the boys are with their father 3 weeks of the month. So what he wants to do, the house is being sold, and then when the house is sold, he wants to relocate them from Victoria to Western Australia, and because of their age, I've been told there's not much I can do about it. Is there anything I can do about it?
Well, it's a little bit more complicated than that. If you were listening to the previous caller, both you and your former husband have what's called long-term parental responsibility, which was the old guardianship, which means that you both need to consent to your children. A significant decision such as a relocation interstate needs to be done by consent. If you actually oppose that decision, you can actually seek to oppose it, but you need to have, obviously, reasons for why it's in your children's best interest. The fact that they are 14 and 16, their wishes and their maturity will be taken into account, absolutely. But the manner in how that's taken into account is important, whether it's done through a counsellor, and also to the courts very wary of children being alienated by one parent, for example. And I'm not saying that this is necessarily happening. There could be good reasons, but if you have real concerns and if you actually believe that it's not in their best interest to relocate, and that could overwhelm their wishes, and also their wishes need to be analysed. And again, that's where your lawyer would need to organise somebody to assess the kids in terms of their age and maturity and what actual agenda is going on.
So what do the kids say, Tessa?
Well, because of the skilled manipulation of the father, which is part of the emotional and psychological abuse, they will go with him because they're scared of not doing what he wants, basically. And they have, the whole reason he wants to locate is they have a stepbrother over in Western Australia. So it's sort of exciting that they think they want to go over to see him. He has his own family and everything over there. So I don't believe it's in their best interest to be alienated from me and my family down in Victoria. So my lawyer actually said that there's nothing she can do. So I just go to another lawyer, or
I think what you need to do is concentrate on why you think yours is the best proposal. And yes, see another lawyer, but talk about, I think if they could recommend, there are many family court consultants, some who are, a lot of them are reasonably priced, who are very bright, and get, if you can get a report and get an expert involved, that would be terrific to see where the kids are coming at, but also too, if you can get agreement to have some sort of child-inclusive mediation.
Sure, but if the kids actually, in Tessa's situation, if the kids actually say, yes, we don't mind, we want to go to West Australia, how likely is it that the courts will in fact say, well, even though you're saying that, we're not going to accept it?
It depends upon the competing proposals. So I've had kids of that age being completely manipulated where the other parent, I'm not saying that in your situation, Tessa, is a complete shocker, and that to actually remain, to actually be, the tyranny of distance might also mean that Tessa's relationship is just decimated with them. So there might be some factors where a psychologist would say, absolutely no, this can't.
How do you prove manipulation?
Through a family consultant, through the expertise of a family consultant.
That would not be an easy thing to do.
No, but it has happened.
Okay.
But that is an option. But you have got a hurdle there. But it's not something I would actually give up on. I'd talk to and see if the kids can actually be assessed by a therapist to see if they feel that the kids are being manipulated or whether it's genuine and would be in their best interests.
All right, Tessa.
All right, thanks very much.
Good luck with that, and I hope things work out. Text messages. So far spent $150,000 on lawyers, 2 years waiting for a judge. The family court's a circus. There aren't enough judges and the lawyers are making squillions. Social workers said yes, the major hospitals, women's, children's have services provided usually by community legal services, so the social workers are the point for referral. And Annie says, very sad to hear Tony's predicament. So easy to get caught up in our own life's bits and pieces. It's humbling to hear Tony speaking, and best wishes to her and her family. And there's lots of people saying things along those lines. Let's get to more callers. Sally Nicholes filling in today for David. Sarah in Eltham. Morning to you, Sarah.
Oh, good morning. How are you?
Good. Welcome aboard.
Thank you. I just wondered, I've separated from my husband in 2012, and our first court appearance was in 2013 to get a settlement. Since then, I've had 13 court appearances because he's totally non-compliant.
13?
13, which has required a barrister at every one.
Any cost orders? in terms of
he's had orders to pay child support and spousal maintenance, but he's now in the federal court circuit with the CSA. And I'm just wondering we've got another trial. We've had a trial, an appeal, and we're now going to trial again. If he gets an order for an amount to pay and he's non-compliant, how does the family court enforce that he will pay? And how long is it going to take?
Yeah, it sounds as if the Child Support Agency are actually running the enforcement for you, are they?
They're running the child support enforcement, but not a settlement.
Yeah, that aspect of the enforcement can be quite severe if they have the running of it. And I think it's a slow process, but they're quite effective. They'll garnish your wages, tax returns. So it's a smart move to actually have the Child Support Agency.
The child support have been amazing, and they have garnished his wage as from 2017.
Sure.
So from 2013.
Also, you finally got something.
Yeah, we've got the child support, but it took 4 years.
Yeah, it's very frustrating.
They are being really good, but they're not going to get me a settlement.
No, so in terms of the settlement, so have you had final orders, or are they being appealed at the moment, are they?
The final orders have been appealed, and we're rehearing it in August.
Right. So once that appeal's actually taken place, there are cost consequences. Were you advised that your settlement was, or the final property orders that are being appealed was just and equitable? Has anyone advised you about the merits of the appeal? Has anyone said
yes, yeah, we had 21 orders. We got about 15 of them, and a few have been appealed, and that's what the property settlement is.
Because if someone's advised you that the appeal, who's appealing them? It's who's actually running the appeal? Your ex-husband?
Yes.
Yeah. If the appeal is without merit, there are quite severe cost consequences in the appellant jurisdiction. It's a little bit harsher than the standard family law system, so you might find that's a disincentive for it to keep going.
You've got no choice, have you? Though
it's keeping on going.
Yeah, you've got to keep.
Yeah, you have to.
You've got to maintain
keep the faith, and there will be consequences. But also, too, once the orders are made, they'll either be reinstated, made again. I hope you're not sent back for a rehearing. That only ever happens if there's, it can happen, but if there is issues of fact that need to be determined again through evidence that wasn't at trial. Doesn't sound like you're one of those cases. So if you do get your orders made again through the appellant court, then there are enforcement provisions, and I'd say after an appeal there are contravention possibilities, and there'd be cost consequences if your husband didn't comply with them.
No settlement negotiations that work, Sarah?
We've tried mediation. He won't mediate.
All right. Well, sounds like you've ticked all the boxes.
But actually, he won't comply. Like, he doesn't comply.
Then that gets pointed out to the court. The court has the power ultimately, Sally, do they not, to enforce?
And contraventions get more serious as you have to particularise them and have your lawyers detail them, but they can be that serious that there can be incarceration. So you need to make that call with your lawyers. If you're in that unfortunate percentage, that slim percentage that Jon actually mentioned at the beginning of the program, where you are in court and you're going through that much litigation, then the consequences of contravention, the court will become more and more serious, including incarceration and fines.
All right, Sarah?
Well, it's all very well to say that, except for 5 years, there haven't been any consequences, and I don't think the family court have been at all fair to me and my family.
What do your lawyers say about that in terms of contravention?
They say that's just the family court. It just takes 5 years.
It's an imperfect system.
Absolutely.
There's no doubt about
Very
that,
frustrating.
Sarah. It's not often, though, that a case is as bitterly contested as yours sounds, that it is that absolute, hardcore, tiny, fraction of a percent you've ended up in one of those.
Unfortunate. We often say to people that it's very rare. Sometimes people stop working, and it's that 1% of people stop working to avoid paying child support, for example.
Yeah.
But it does happen.
Yeah.
It sounds like you've actually fallen into that
It
category.
Oh, so just keep going.
Keep going. Keep the faith.
Thanks, Sally.
I'm so sorry you're going through that.
Yeah, and good luck.
Thank you.
All right, Michelle in the city waiting. Good morning to you, Michelle.
Good morning. I have 2 children who are 10 and 8, and in the past 5 years we've had family orders in place. The last 3 months the children have been pleading to me not to return them to their father. I've tried to discuss it with him, but he's not communicating very well, I
Yeah.
guess.
How often do they see him?
They see him midweek on every Wednesday and then every second Thursday, Friday and the weekend.
And what are they upset about? What are they complaining about?
The inconsistency, no respect, no communication. They feel as though they're not welcome to be there. He's not respecting them and yells at them. And it's quite different to their home with me, obviously. So they don't like the turbulence.
Yeah, and at that age, they're I know at a critical age, but there's something that have you offered to go to mediation with him to discuss this?
Yeah.
And there's been a
he
no?
won't mediate. No, yeah.
It's a sad fact because I just feel confident that if your 8 and 10-year-old and your family were in front of a good therapist, there might be some moves made, but particularly one who actually works in the family court, who can perhaps read the Riot Act a little bit to their dad to explain that you don't want to have to go to court to resolve these types of disputes. This is exactly the type of case that really should be resolved by some rugged and good, robust therapy. And what your children are complaining about, obviously they need to be validated, but there's some strategies that can be put in place. And it's a tragedy when these types of cases do go to court. So if I was acting for you, what I'd be really trying to do is to make it clear that you don't want to go to court, that you need to actually document where the children are at. And there are some brilliant options in terms of child inclusive mediators who could try and get over this, but also to take them to a counsellor to really help that third party articulate what's going on. And when someone sees a third party psychologist preparing a report, they might think a little bit differently about not engaging with you as well.
Yeah, there's orders in place that if we were to seek any therapy for the children, both parties need to agree. And unfortunately, he won't agree for me to pursue with that. The school actually have asked as well if they could, speak to someone internally, and he keeps denying that right to them.
Well, that's the discreet nature of what your application should be. Again, I'm so loath again to put people into the system, but in a perfect world, you'd be saying, I'm going to have to go to court to seek a variation. I don't want to do this. It's not good for me, for the children, for you.
For our bank balances?
No, not at all. And it will only antagonise. So, but the court will be sympathetic if you've tried and you've put in writing that you don't want to litigate, but this is your only choice. Please, let's agree to vary that order and see somebody. They'll be sympathetic, I'm sure, in terms of making that order, but it's something that you want to try and avoid and to discuss with your lawyers.
Good luck with that, Michelle. I hope that helps.
Okay. Thank you so much, Sally.
Oh, pleasure.
Good on you, and thank you indeed. Some text messages just before we finish up, Sally. I know an ex-family court judge who moved to another court and jokingly said dealing with criminals is much better than dealing with people's family breakups. I think there's only a very limited number of people who moved from one court to the other, so we might know who they're talking about there. Dear oh dear. And are there any men calling up? The answer is no. In fact, there haven't been any. And indeed, yes, if there's been a distinctly one-way traffic in this session, that's an indication of what it's like working in this jurisdiction, in fact.
From time to time.
I think that point needs to be made, Sally.
Although we did have some male callers last time.
Yes, we did. But typically, the stories we've been hearing today are not, are they in any way unusual in the daily work of a family lawyer?
No, not at all.
Not at all, in fact. And if there are people out there saying, oh, this is all one-sided and, oh, you're men bashing again, well, quite frankly, if you spent some time in the family court or sitting in Sally's chair, you would start to see things a little differently too. And quite frankly, the family law system is full of these sorts of experiences and stories. It's by no means atypical, what we've been hearing today. And that's a sad truth.
No, it certainly is. And I think the use of consultants and therapists, if people can avoid going to court, I would absolutely recommend it. It is the court of last resort. It is imperfect, and there are some fabulous people who work with children, work with families, who can really try and get an impasse or break an impasse for families. So I'd really recommend it.
I do wonder though. I've never heard a good reason why not to mediate.
Oh,
and I think
exactly.
what the courts should be doing is saying there's a presumption that things should be mediated, and if one party actually even just point blank refuses to mediate, that will be a mark against you when you come in front of a judge instead.
I agree. At the moment with kids' cases, you must mediate. Now
Yes.
you have to get a mediation
But
certificate.
on property and other issues,
I agree with you.
it should be regarded, well, if you are the one who refused to mediate, you better have a damn good explanation to make when you come in front of a judge instead, because you've put everybody to a lot of expense, a lot of trouble, a lot of anguish because of your refusal to mediate. Now, give it your best shot. Let's do that first.
And you're putting your family in front of this imperfect situation.
Exactly.
Someone else is making a decision about your family.
Yep. Sally, thank you.
Pleasure.
Very generous of you to give us your time today. Sally Nicholes from Nicholes Family Lawyers, and David Whiting should be back in the chair next week. It's 25 to 11. That means I'm very, very late for the news headlines.